Centre for Public Legal Education Alberta, CPLE, is a non-profit organization with the goal of making the law understandable for Albertans. CPLE provides legal information and education to the public. Only lawyers can provide legal advice. Look for our contact information at the end of this video. Enjoy!
The Centre for Public Legal Education Alberta runs a residential tenancies legal information program, which provides legal information for landlords and tenants in Alberta. The program is funded by the Alberta Real Estate Foundation and has been going strong since 2000. You may be familiar with our Laws for Landlords and Tenants in Alberta website. We get many questions every year about renting, from both tenants and landlords throughout Alberta. We also keep track of popular search terms on our website, so we have a good idea of the types of issues or questions that tenants and landlords deal with frequently. This video is part 2 of a compilation of our top 10 housing law issues. We will discuss security deposits, landlord entry, repairs and pests, guests and other occupants, and shared accommodation. Security deposit disputes are a common issue. Let's take a look at a security deposit problem. When the tenant moved into their apartment, there were already holes in the wall. The landlord did not do a move-in inspection. The tenant is now moving out, and the landlord is saying that the tenant caused all the damage. Can the landlord keep the tenant's security deposit? Well, in this particular situation, the landlord can't keep the security deposit. Without an inspection report, there's no way for the landlord to prove that the damage wasn't from before the tenant moved in. Landlords can ask for a security deposit when a tenant moves in, which can be no more than 1 month's rent. A security deposit is used to cover the costs of repairs to fix damage beyond normal wear and tear, cleaning beyond normal wear and tear, missing keys, and unpaid rent or fees. Inspection reports document the physical state of a rental property when the tenant moves in and moves out. They must be done within 1 week of the tenant moving in or out. The tenant should attend the inspection with the landlord, and it's also a good idea for both landlords and tenants to take photos at the inspections. The tenant also has to cooperate to get the inspection scheduled. A landlord can do an inspection without the tenant if the landlord gives the tenant 2 different possible times, which means during the day, not on holidays, and on different days. After completing the inspection, the landlord must immediately give the tenant a written inspection report. Both the landlord and the tenant should keep a copy of any inspection reports in case there is a dispute later on. If an inspection report is not done, then the landlord cannot keep the security deposit for damage to the property. The landlord has 10 days to deliver a statement of account with a check for the security deposit if there is money owing after any deductions to the tenant. If a tenant does not receive the statement of account and security deposit from the landlord within a reasonable period after the 10-day deadline, then they can contact the landlord to see what is going on, and if there is no response, the tenant can write to the landlord requesting the return of the security deposit. If the deposit is still not returned, the tenant can make an application with the Residential Tenancy Dispute Resolution Service for its return. So on to the next issue of landlord entry of unit. It's 2 days before Canada Day. A tenant receives a notice that the landlord will enter their unit to put a flag up on their balcony for Canada Day celebrations. Can the landlord enter the unit to put up a flag? Well, this is actually based on a question we received from a media outlet during Canada Day one year. The backstory became a bit of a media sensation, so I'm sure you'll find it if you search for it online. Under the RTA, there are actually very few reasons a landlord or property manager can enter a unit without the consent of the tenant. Entering a unit to put up a flag is not one of them. The RTA outlines when a landlord can enter the rented premises. A landlord cannot just show up at a tenant's door and demand to be let in. Unless the tenant consents to the landlord entering, the landlord has to give signed, written notice to the tenant stating the reason for entry and the date and time the landlord will be entering. This notice must be served at least 24 hours before the time of entry stated in the notice. The landlord must give a valid reason for the entry. The RTA states a landlord or their agent can only enter to inspect the state of repair of the premises, to make repairs, to control pests to ensure the property meets health standards, to show the property to people who may want to buy the property, or to show the premises to potential tenants at the end of the lease. If a landlord is entering without notice, the tenant's first step is to advise the landlord of their legal obligation to provide advance notice of entry. If the landlord continues to enter without notice, the tenant may consider calling Service Alberta and filing a complaint against the landlord, or filing an application at the Residential Tenancy Dispute Resolution Service for compensation or to end the tenancy early. When it comes to law, there are usually exceptions. When it comes to entry without notice, there are very specific reasons a landlord can enter without notice to a tenant. So for example, if the tenant consents to the entry, if there is an emergency such as fire or flood, if the tenant has abandoned the premises. In that type of situation, there must be clear evidence of abandonment. So for example, the tenant stops paying rent, the tenant's mail is no longer picked up or delivered to the premises, the utilities are disconnected, the landlord does not see or hear from the tenant in a long time despite multiple attempts to contact them. A tenant has a bed bug infestation in their unit, but their landlord is not responding to the problem. The tenant is thinking of hiring fumigation services themselves. So what can they do? Will the tenant be able to withhold rent if the landlord does not deal with the problem? The RTA does not deal specifically with repairs and maintenance. Tenants may be responsible for making certain repairs and should check their lease for more information. Having said that, landlords do have a responsibility under the Public Health Act to ensure their properties meet minimum housing and health standards. So for example, keep the fridge and stove in operating condition, keep the property free from pest infestations, provide hot running water and keep the property heated to a minimum temperature, keep property waterproof, windproof, and weatherproof, keep stairs, railings, windows, and doors in good repair. If a landlord is not meeting standards, a tenant can call 811 to talk to a health inspector. Minimum housing and health standards are enforced by public health inspectors. An inspector can investigate the situation and has the power to order the landlord to fix problems. One important thing to keep in mind is that the tenant must continue paying rent when waiting for repairs. Otherwise, they can be evicted for not paying rent. Where a landlord is aware of a bedbug infestation and does nothing, a tenant can consider recovering damages. This means that a tenant can start an application to the RTDRS or provincial court to recover any expenses that they pay for out of pocket to deal with the problem. So for example, fumigation costs or hotel stay. A tenant's family member started staying with them lately. The tenant did not mention it to the landlord. Does the tenant have to mention the family member to the landlord? And can the landlord evict the tenant? In this type of situation, the landlord has a right to know how many people are living in the rental unit and who is living in it. A landlord's approval of a person is required to live on the property, otherwise the landlord can ask the person to leave. Tenants should always review their leases and get their landlord's approval before allowing guests or other occupants to move in or stay with them. Otherwise, a landlord can give 14-day notice if someone is living without permission with a tenant. A tenant may even be evicted for failing to get the landlord's permission for guests and other occupants. Shared accommodation is one of the most searched for topics on our website. So does the RTA apply to obligations that roommates have to each other? How about when the landlord shares living space with a tenant? The answer to both of these questions is no. The RTA sets out the rights and obligations that a tenant has to a landlord and the landlord has to a tenant. the RTA does not usually apply to the rights and obligations that roommates have to each other. It is common for roommates to enter into roommate agreements so that each roommate knows what is expected of them. CPLE has a resource on shared accommodation and a sample roommate agreement that can be downloaded for free on our website. If the landlord shares living space with the tenant, such as a kitchen or bathroom, the RTA does not apply. Tenants who live with their landlords do not have the same protections as tenants who are covered by the Residential Tenancies Act. So in this type of situation, the landlord and tenant should have a written agreement between them that outlines the rights and rules that each has to follow. CPLE has created a sample living with your landlord agreement that tenants can use if they decide to enter into this type of living arrangement. It can also be downloaded for free from our website. For landlords, we also have a booklet called Renting a Room in Your Home that provides more information. Don't forget to check out our Laws for Landlords and Tenants in Alberta website. To access all of our publications about renting in Alberta, you can download them for free on our website, or you can contact us to get a printed copy.
Thank you for watching this video from the Centre for Public Legal Education, Alberta. We endeavor to make the law understandable for Albertans. You can find CPLE's resources on our website, cple.ca, or reach us via email at info@cple.ca, or simply by phone at 780-451-8764. Until next time.